So the rule, the first, you can say that this is literal rule of interpretation, but we also call it literal, construction. And it makes more sense to, based on the distinction that we made earlier, it makes more sense to say it's a literal rule of interpretation. So it's not, it's very simple for you to understand. Although as you look deeper into it, you'll see that there is a little bit of complexity in this as well. So when it says literal rule of interpretation, what does it really say? So when you are to find the true meaning, true intention of the legislature from the statute, from the legislation concerned, how do you find the meaning? So the meaning, the way to find the correct meaning would be to use the rules of grammar in that language. So you can say that this is the grammatical way of interpreting, and finding the meaning to a particular statute, particular legislation. So that's why we call it literal interpretation. So you look at the literal edges, okay, the literal edges of the legislation, okay, and then you find the meaning. So that's why we call it literal construction, or rule of literal construction. So the meaning that you give to the words in a particular statute would be the natural, the grammatical meaning, okay. The problem is that quite often, as H.L. Hart had said, in most cases you will not come across any difficulties because we agree on the meanings, okay? There is broad agreement, otherwise communication will not be possible. So there is broad agreement among us as to what meaning words convey. So that's why we say that, well, how do we get the meaning? We get the meaning from the natural or grammatical meaning of words as are there in the statute. Now you know that statutes convey will or the intention of the legislature, the will of the legislature. Okay. Now when we talk about will of the legislature, well, we are referring to the will of the legislature as legislated in the statute, as legislated in the legislation. Okay, so that's what we look at. Okay, we don't go back and ask them, okay, what did you really mean? So we are not concerned about, for example, all the discussions, deliberations that happened in the parliament or any other state legislature to find out what they meant when they used a particular word. Okay, so maybe there was a debate with respect to particular expression used. As a judge, if you were to decide a matter based on a particular provision of a statute, it should not be your first instinct to go and look at how the discussion had played out, how the discussion on a particular expression as you come across in a legislation, a statute, and had been discussed. Okay, you don't do that. So where do you get the meaning from? As the rule says, the first rule of interpretation, the first rule of construction, whatever you call it, if you were a judge interpreting the meaning of a particular statute, the first instinct for you should be to find the meaning from the literal edges, using the grammatical or natural meaning to the words of the words. Okay, so that's what you do. Now, here's the thing though. Okay, so there might be certain legislation which are for certain specific areas, specialized areas. Okay, so you might come across technical legislation. Okay, technical legislations. So in those technical legislations, the words which are used in those areas. So for example, legislation with respect to a particular trade, particular industry practices, etc. In those specific areas, the words might acquire a particular meaning. Okay, they might be using a word in a particular sense within that trade practice or a certain area. Okay, so if the legislation is a technical legislation addressing a particular technical area, then the meaning, okay, will not be the ordinary meaning, okay, ordinary grammatical meaning. Okay, so the word might have acquired a technical meaning in that particular area. Then you as a judge has to assume that, well, the legislature used the word in that technical sense. Okay. So in R versus Commerce, Commissioners of Income Tax, I will write it here, just a second. So in this particular case, as you can see, R versus Commissioners of Income Tax, it was said, here they go the other way around. Okay, so it was said, the first and most elementary rule of construction is that it is to be assumed that the words and phrases of a technical legislation are used in their technical meaning if they have acquired one, otherwise in their ordinary meaning. Okay, so if the legislation is a technical legislation, basically it deals with a particular trade practice, whatever, okay, industry, it's very much possible that the words used in that legislation are used in the context of that particular trade practice, etc. Okay, so if it is of that sort, and if the word has acquired a technical meaning, then you as a judge, okay, while interpreting the said provision, has to give that appropriate technical meaning. Okay, otherwise, if not, then the ordinary meaning, ordinary natural meaning, okay, or use it in the grammatical sense. Okay, and the second, so it's part of the same rule. Okay, second, that the phrase and sentences are to be construed according to the rules of grammar. So when you construe, okay, a particular provision of law, how do you do that? You use the rules of grammar of that particular language. Okay, but here's the thing, one more word of caution for you, that grammar should, however, not supersede what the legislature might have intended to convey. Okay, so rules of grammar are of assistance for you. Okay, they are of assistance for you in deriving the intention of the legislature. Okay, but they should not be the only factor. Okay, they should not be the only factor. So the rule is that if the word has acquired technical meaning, give it technical meaning, otherwise the ordinary meaning. And what else do you require to interpret, to construe the meaning? You have to use the rules of grammar of that particular language. But at the same time, the idea is that you are not to allow the rules of grammar to supersede what the legislature might have intended. So, and then so this is the order in which you go. Okay, we will look at certain other cases. So what happens in today's times is that, so in earlier times, if you were to look at legislation, a couple of 100 years back, the legislations were not as detailed as the legislations are today. Today, the legislations are not merely drafted by, some limited number of people. Expertise, okay, experts from different fields are invited. Okay, so many technical helps are taken, and lots of people are involved. And modern process of legislation is also quite complicated. So that ensures that the modern legislations are quite lengthy and very detailed. Okay, so that requires that, okay, increasingly as time passes, the tendency is that the rule of literal construction has to be applied. Okay, so that is the safest rule of interpretation. This is something that has been said by Lord Evershed. So he said that the length and detail of modern legislation has undoubtedly reinforced the claim of literal construction as the only safe rule. Okay, so as legislations become more detailed, the more we should assume that the safest rule for the judge to apply, to interpret them, would be the literal rule. So are you guys with me so far?
Yes, sir.
Okay.
Yes, sir.
So do you see the order in which we are to interpret, construe a particular particular law? The order is that, if you are to go ahead with the ordinary plain meaning, okay, the natural meaning. So you can say the dictionary meaning. Okay, you can also say the dictionary meaning. Okay, the plain natural dictionary meaning. And however, if the word has acquired a technical meaning, then you have to use the word in that technical sense if the legislation addresses a technical area. And then to interpret it, you have to use the rules of grammar. So that's what literal construction is all about. Okay, so it has been further said in Barrel versus Forgery. Okay, I will write it here. Barrel versus Forgery, that the safer and more correct course of dealing with a question of construction is to take the words for themselves and arrive, if possible, at their meaning without, in the first instance, reference to cases. So you see the next important point that has been made here. So you know that legislations are more important than case laws. Okay, obviously we cannot ignore case laws, because quite often words which may convey ambiguous or absurd meaning, okay, in those situations you have case laws that clarify those meanings. So that is not denied, those are important. But if you were a judge and you were to find out the meaning of a particular expression in a statute, your first response should not be to refer to the cases. Okay, first you look at the words themselves, okay, and arrive, if possible, as has been said, at their meaning without, in the very first instance, reference to cases. So do not at the very first instance jump to cases. First start with the legislation and then to cases. So that's what had been said in this particular case by the name Barrel versus Forgery. So the underlying idea is that, well, legislation are the expression of will of the parliament, okay, and I'm talking about all these cases without giving you guys a context. Most of these cases are British cases, okay. Now, what's the form of government that they have there? They have a parliamentary form of government. So they are also based on this idea of parliamentary sovereignty. Okay, there is a kind of supremacy of the parliament. Okay, and judiciary, the judges, the court has the understanding is quite clear that legislation, policy making is the business of the legislature. The judges are merely to apply the law as is laid down by the legislature. If a particular legislation is not good, then it is not the business of the judges to negate or nullify it. It's the business of the people who have elected these legislators and then sent them to the parliament to then hold them accountable for improper obnoxious legislations. It's not the business of the judges to do that. Okay, obviously there are other human rights constraints and all that. We are not going into all that. Generally, this is the understanding that they have in parliamentary forms of government. To a certain extent, obviously subject to the restraints imposed by the constitution, we follow the same rule in India, that it is not the business of the judges to make policies. It is not the business of the judges to make legislations. It's the business of the parliament, and legislations are the expression of the will of the parliament. And if that's the case, the best way of interpreting and applying the law would be to look at what the parliament has intended. So intention of the parliament, or for that matter, legislature here, must be deduced, okay? And how do you deduce? From the language that has been used, that is the litera legis, okay? So beliefs, assumptions of those who frame acts of parliament cannot make the law, okay? So you will look at the language, okay? Even when you draw the intention of the legislature, you will draw that only from the language that has been used, not based on the beliefs, assumptions of those who frame the acts of the parliament, okay? Because their beliefs and assumptions cannot make law. So we are to look at the legislature, we are to look at the parliament as an organic whole. So you do not look at what were the subjective beliefs, assumptions of, okay, that MP or that MP and whatever. You don't do that, okay? You don't do that. The entire legislature has to be treated as one organic whole. And if it has intended something through a legislation, well, you draw the meaning from the language that has been used in that particular legislation. So when the language which has been used in the statute, okay, admits plain admits only one meaning, okay, there is no question of ambiguity, there is no question of doubt, okay, there is no other alternative meaning available to you, and the language is quite plain, okay, in such case the rule of construction would be literal rule of construction. So if that's the case, if the language is plain and does not admit multiple meaning, okay, in such situation, whether the same is acceptable or desirable, etc., should not bother the judge. Okay, the judge should not care about all those things. If the language is plain, clear, unambiguous, that does not admit of multiple meaning, then the judges will not go into the questions of acceptability, desirability, or undesirability of whatever has been said in that statute. So, are you guys with me till now?
Yes, sir.
Okay.
Yes, sir. Yes, sir.
Very simple.
Yes, sir.
It's very simple. Nothing difficult here. Okay. So, Lord Wensleydale, I'm using that book I had referred, okay, Maxwell's, for introductory discussion on this topic. All other books that you studied, they have taken from, this one only. Then we will look at some other cases later on, don't worry. So, Lord Wensleydale in Gray versus Pearson, okay, Lord Wensleydale in, we'll write this in just a second, just so that you don't miss. Lord Wensleydale in Gray versus Pearson had said, in construing wills, okay, and indeed statutes and all written instruments, okay, so it's not just talking about statutes, okay, it's talking about wills, okay, because that's also a kind of legislation, okay, the person who writes legislates for, themselves, okay, so it's saying in construing wills and indeed statutes and all written instruments, the grammatical and ordinary sense of words is to be adhered to unless that would lead to absurdity. So I told you that, yeah, ambiguity, absurdity, those are certain exceptions, but not in all cases though. Be very careful. We said that, okay, unless that would lead to absurdity or some repugnancy or inconsistency with the rest of the instrument. So these are some of the exceptions that he is telling us, okay. So those are absurdity, repugnancy, or inconsistency with the rest of the instrument. In which case, the grammatical and ordinary sense of the words may be modified so as to avoid that absurdity, repugnancy, and inconsistency, but no further. Okay, so the deviation, okay, from the grammatical rule is allowed only to the extent that you are trying to remove the absurdity, the repugnancy, and the inconsistency, and you do not go beyond that in order to do justice and all that, okay. But then like our Supreme Court has the power to do complete justice, so that's there, but those powers are also given by the Constitution, okay. But other than that, okay, if such constitutional questions do not arise, other than that, if we are restricted to interpreting the statute itself, okay, you are not allowed to deviate from the grammatical rule unless in these cases that we have just discussed. So that's what in English context Lord Wensleydale had said. So another case, okay, I will write it here. Now here's something, okay, remember, okay, these cases that we are discussing here, I mean the quotes from these cases that we are discussing here, well, what's the precedential value that they have, okay. It's not for their precedential, okay, value that we are looking at. It's just that, okay, they have certain authority that they have acquired, okay, these quotations that we are discussing, okay. So and they convey certain accepted ways of interpretation. So it's for that reason that we are looking at this, okay, not as as some kind of precedence, having precedential authority, not for that. It's just that some accepted practices which have been there for a long time have been said by some very reputed judges in important cases. That's the authority we are concerned about here. So in this particular case, Lord Esher had said in R versus City of London Court, okay, it's a Queen's Bench case, where he said, where by the use of clear and unequivocal language. So see, it's talking about an exception here though. So where by the use of clear and unequivocal language. Okay, so the language has to be clear and unequivocal, capable of only one meaning. Anything is enacted by the legislature, it must be enforced even though it be absurd and mischievous. Now this kind of goes against what you have read in the previous case. So the difference is this, okay, as opposed to what we have just read in the previous case and this one. The difference is this, that in this particular case it was said that, well, you will have the option, okay, only when you have the choice there. Okay, so if the word, okay, if the word is not clear, if the words used, they do not convey clear and unequivocal language, okay, and if it is not capable of one meaning, okay, in that case only, as I am assuming here, that Lord Asher says that you can then have the discretion of choosing one over the other, okay. But in other cases that it leads to some kind of absurdity and all that, you will not deviate. So that's why it says that where by the use of clear and unequivocal language capable of only one meaning, anything is enacted by the legislature, it must be enforced even though it be absurd or mischievous. So you see, this is little more extreme version of what we have read. But in subsequent, subsequently you will see that we will look at certain other rules of construction, and where they say that if the interpretation leads to absurdity, then judges do something, okay, then judges apply another rule known as the golden rule of construction, okay. So we will deal with it there, but this is like an extreme version of the same rule, that even if it leads to some kind of absurdity or mischief, even then the judges will not try to fix that, okay, unless the language is unequivocal. So that's what Lord Asher had said in this particular case. Further, again in another case, okay, by the name Gwynn versus Burnell. Just a second. In this particular case, Gwynn versus Burnell, it was said that the interpretation of a statute is not to be collected from any notions which may be entertained by the court as to what is just and expedient. So see, the court will not look into efficiency. The court will not look at whether something is just or unjust, okay. None of them should be of concern for the court, okay. The expediency, okay, the efficiency, that is considered by the legislature, and it's not business of the judges to do so, okay. Nor will it go into the question of justness or unjustness of a particular statute. Further, in another case by the name Whitehead versus James Todd Limited, just a second. It was said that words are not to be construed contrary to their meaning as embracing or excluding cases merely because no good reason appears why they should not be embraced or excluded. So you see that this is a natural implication of the rule that we have been discussing, okay. So the legislators choose to use a particular word, okay, and they neither extend nor do they intend to limit the meaning of that particular that they used, okay. So unless such intention appears, okay, the judges cannot extend or embrace or exclude, okay. That's what has been said. So words are not to be construed contrary to their meaning, okay, if the meaning allows, okay, as embracing or excluding cases merely because no good reason appears why they should not be embraced or excluded. So what is being said here is that, so do not exercise your own judgment, your own choice in extending or limiting the meaning of the words unless they are clear from the words themselves, okay, and the context. So that's what had been said in Whitehead versus James Todd Limited. We have another case. So for your sake, okay, don't worry about remembering all the names of the cases. I'm just referring to them, so I'm mentioning this name. So as long as you remember the rules, okay, and its different aspects of it. As long as you remember it, as long as you understand it, not just remember, as long as you understand it, if you write that in the examination and explain, that will suffice for you. So do not worry about remembering all these different cases. So in this particular case, Cartilage versus E. Jopling and Sons, okay, it was said, where by the use of clear and unequivocal language capable of only one meaning, okay, anything is enacted by the legislature, it must be enforced, however harsh or absurd or contrary to the common sense the result may be. Okay, so the same idea. So judges do not get to lessen the rigor of a statute, okay, if that's what had been intended by the legislature. It's for them to do, okay. So they are not to use their mind, their own judgment, and then say that, well, this is against common sense. They cannot do that, okay. You are to assume that the legislature has done it, and it's for them to do, okay. We will not get into it, but there are certain exceptions that we are going to discuss later on, okay. So that exception usually is that, well, the language permits, okay. Well, the language permits, or the language is not clear enough, that it does not unambiguously say something, that it allows multiple meaning. In such case, you will go with the meaning that allows, for example, getting rid of that absurdity, or getting rid of that harshness, etc. So unless that language allows, the judges cannot use their own discretion or use their own common sense, etc. So that's what had been said in this particular case. So we will look at 4 cases today, and with that I would end because I have some other work to do. But these 4 cases will tell you the extremes to which literal rule goes. Okay, so one very important case is by the name Short versus McCarthy. Okay, just a second. Short versus McCarthy. Now, remember this, when it comes to statutes of limitation, judges do not get to exercise their discretion, okay? So if the statute of limitation says that a particular suit is to be brought within 3 years of, since when the cause of action arises, okay, you have to do it within that time. If the time elapses, okay, then judges do not get to exercise any discretion in such situation. So one such case is this. The cases of Short, by the name Short versus McCarthy. So it's a case of statute of limitation, okay, that said actions not to be brought after the lapse of certain periods of time. So it said certain periods of time, okay, not necessary for us, from the accrual of cause of action, okay. Now what if the cause of action, okay, that's what the from where the time calculation of time starts, okay. What if the cause of action was not discovered, okay, nor was it practicably discoverable, or was fraudulently concealed by the wrongdoer? What then? Should the judges then get to exercise their discretion and then extend the limitation period? In this particular case, it was held, okay, so look at the extremes, okay. We have other examples where the decision had been otherwise. But in this particular case, look at the look at the harshness of this particular rule. Even though this was the case, okay, the judges did not allow institution of such suit because the limitation period was over in this particular case. We have another very important case by the name Miller versus Salomons. Miller versus Salomons, okay. So in this particular case, so the instant act concerned required MPs before voting in the House, okay, to take the abjuration, okay, an oath basically, in a form which concluded with the declaration that it was taken, now this is important, on the true faith of a Christian, okay. So the oath, the abjuration included this, okay, on the true faith of a Christian. Okay. Now, what about a MP who was a Jew? So that was the problem that emerged in this particular case. Okay, what about an MP who was a Jew? So in this particular case, it was held that cannot do that, because it said on the true faith of a Christian. The MP wasn't a Christian, so yeah, they went ahead with the literal rule of interpretation. So it wouldn't be possible for the MP who was a Jew to swear by this. So another important case is by the name Rutherford versus Moore. I will type it here just a second. So yeah, this is a particular case, okay, where a particular act by the name Agricultural Holdings Act, okay, of 1948, a particular section 1(2), okay, was concerned, okay, and it defined agricultural land, okay. It defined agricultural land as land used for agricultural purposes, okay. So land used for agriculture, which is so used for the purposes of trade and business, okay. So it's a very interesting case, okay. So in this particular case, okay, for many years the land was used to support in this particular case, the land was used for grazing horses, okay, in pursuance of a particular business, okay. So horses were being grazed on that land, okay. However, okay, the land was not used for so the land was used for some certain non-agricultural purpose, okay, but they were basically grazing their horse on that land, okay. So they were growing grass, okay, and horse, it doesn't say anywhere whether they were growing grass, maybe it was, okay. So they were basically grazing their horses on that particular land, okay. Now the very fact that horses were grazing on that land, it was held that it comes within the meaning of agricultural land, okay. Now this is ridiculous, okay. Why is that? Because the actual purpose for which the land was used was not for the sake of grazing. It was for some other business, so that they had a certain riding school on that particular land. So even though that was the case, it was still held to be within the meaning of agricultural land, because they were grazing their horses on that land, and so that came within the meaning of agricultural land. So that's the kind of decision that you come across, okay, when you adhere strictly to literal rule of interpretation. So one last case that we are going to discuss today is by the name Paulie versus Worldall. Just a second. Paulie versus Worldall, okay, 1966, okay. In this particular case, we were concerned with an act, okay, that made it an offense, okay, to drive a motor vehicle without reasonable consideration for, it says, other persons using the road, okay. So I have a question for all of you. So what about a passenger sitting in the car which was being driven? Will they come within the meaning of other persons using the road? Are you guys there?
Yes, sir.
So did you get what I was trying to say here? So in this particular case, an act made it an offense for one to drive a motor vehicle without reasonable consideration for other persons using the road, okay. Now this phrase, okay, other person using the road, okay, do you think a passenger sitting in the vehicle being driven will come within the meaning of other person using the road?
Yes, sir. Yes, sir.
Mm-hmm.
Yes, sir, because it was mentioned that the person driving the vehicle. Yes, people sitting there.
Yeah, exactly. So that's what was held in this particular case, okay. So if the driver drives in such a way so as to cause, okay, some cause some harm to people, one of the passengers sitting in the vehicle, even for that, the driver can be made liable under this particular act. So that's what had been held in this particular case as well. So with these cases and discussions, I'd like to end it for today. Tomorrow we are going